For now, we meet in this context, and I hope we only meet in this context, because unfortunately, given the nature of my practice, most people come to me when they have a problem, and it's a significant problem. It's a licensing problem. It's a, it could be a game changer in their career. And so when they're done visiting with me, or they're done with my representation, oftentimes they're very happy, and P.S. I hope I never see you again. And I understand that completely. I wouldn't want to see myself either. So we're going to go over, we have a lot of ground to cover, a couple of hours to do it. We're going to sort of broke this up logically in two different segments. The first hour, more or less, we're going to kind of focus on some ethics-specific issues and how ethics issues very commonly arise in the practice of intellectual property law. Some of the, I'll call them hot topics, although oftentimes these are repeats of a common theme that we've seen over and over and over and over again. But there are also some new changes in legal analysis and thought and evolution of thinking at the USPTO that impact ethics issues and ultimately downstream impact how we all practice. The second part, which we'll talk about, I believe it'll be after the lunch break, is going to kind of focus on the ethics issues, but tie them into real life litigation matters, not in litigation vis-a-vis the bar, but malpractice, your straight up malpractice case, whether it's patent litigation malpractice or patent prosecution malpractice or licensing malpractice. And so you will get to see sort of how the ethics rules build into the secondary pieces, which is your professional liability, predicated on, in part at least, on ethics issues. So I don't know how you all are working it with questions, but please, I want to be engaged. I want you all to engage. So if there's something that pops up and you want me to drill down on something while we're speaking live, I mean, it's okay with you. It's fine with me. I want you all to, feel engaged, interactive, because as I said, we're going to be together for a while. So just a little bit of historical background. I call it Meet the OED. And just by sort of a show of hands of people here, how many of you all are registered patent practitioners or patent agents? So, okay. So you all have happily met the OED when you dealt with the E side, which is the enrollment side. And that's the only time you ever want to hear from the OED. It is the one time you'll be happy to hear from the OEDs when you pass the exam. If you pass the exam and you get your reg number, that's it. We're done. You don't ever want to hear from them again. If you ever get any future correspondence from them, well, there's only two types of correspondence you'll get with them from them after you typically get your enrollment. One is a survey that they kick out every few years to a chunk of patent practitioners, and they essentially say, hey, you still want to be on the register? If so, then return this form and check off the box indicating that you still want to be on the register, and we'll keep you on the register. They send that by regular US mail, okay? That's an important part of this. The second time they'll reach out to you, generally speaking, is in a certified letter, return receipt requested. That's not a good sign, okay? When you get a certified letter from the OED, it's not to say you did a great job on something, we want to commend you. That's the kind of thing where they start asking questions. It's kind of like having the police knocking on your door and saying, can we come in and speak with you for a while? And maybe it's not about you per se, but if it's a registered certified mail directed to you, they're coming to talk to you. It's an investigation, or they're a precursor to an investigation, and that's when you're my heart stops. So I kind of feel like when I get letters from the OED, now I get them all the time in my business, and my heart still races when I get the letter, and all my letters are return receipt requested. And I still like, wow, God, I wonder if this is about me or okay, this is just about a client. Fine, I can deal with that. But going back to the practitioner survey side of things, this is really important because I've had a number of clients that this has happened to, and it's unfortunate. So here's the deal. They'll take it in the guise of saying, we want to keep our registration list up to date. So you think, okay, I'm admitted to the bar. You know, do I need to recommit? Like, I still want to be admitted to the bar. And in my state of Maryland and in the District of Columbia and in Virginia, as long as I'm paying my dues, you know, they don't care. They'd love for me to pay dues and not do anything. But with the OED, what happens is that they'll send you this letter, and it'll come regular mail. And think about it now. They have whatever address they have for you is the OED's address for you. But that's different than the address that may be different from your actual address that you actually use. You may be corresponding with the PTO and patent and trademark matters. You may have moved firms. You may have moved your official address. You know, depending upon when you became registered and when you gave OED your official address, they have one repository of official addresses. That's what they go to when they send these letters out. They don't go look through the files of the patent and trademark matters to cross-reference or cross-check to see if there's a different firm name, address change, or whatever. So what I've had happen, some practitioners have, you know, moved on from wherever they were when they initially became registered, moved on, and, you know, in the course of things they perhaps neglected, or maybe they did and the OED just didn't get it. Two distinct possibilities, but for whatever reason the OED didn't get the new address. It's not in their database. The OED will send the survey letter out asking you whether you want to re-up, and if you don't get that letter, and it says in the letter itself, it's sort of self-executing. If you don't respond to the letter within X number of days, then we will assume that you don't want to be on the register anymore, and you will become administratively suspended, and we'll remove your number from the rolls. And they don't send that to you certified mail return receipt requested, even though it could affect a very important property right. And they don't make any real effort to track you down to make sure, do you really, really, really want to be off the register or not? It's just a sort of a mechanical process of just sending these surveys out periodically, and you won't know you're going to get the survey. It just comes. They have an internal formula where they'll take a chunk of different reg numbers, a range from, you know, 35,000 to 40,000. They'll send out letters to all of those. And so I've had clients who have been administratively kicked out and had no idea, no clue, because they never got the letter. And they didn't get the letter, and their filings are still being accepted by the office. And then one day they'll get a letter saying, you know, you've been engaged in the unauthorized practice of law for the past 3 years. Please explain yourself. And that's a really uncomfortable situation, number one, and it happens all the time. So if there's one thing you can take out of this lecture, out of everything else that you take, is to do this. If you're a registered patent agent or a registered patent practitioner, is to go into the OED, do a search to find out what they have on the OED website for your current contact information. You want to make sure that that's up to date. They put it on you to update it, and it just is one of those things that people just forget to do. They don't think about it. You know, you've got a million other things going on if you move firms. You're not necessarily thinking about updating your OED address because you're updating your address in all of your patent and trademark cases, but not, again, these are two different databases. So there's you Google search OED practitioner search, you type in your own name, you find yourself, and that will be the record of where you're at, where they think you're at. And it may be accurate, but I would bet there's somebody in here or on the webinar whose information is not up to date. And so just change it, just be mindful of it. It's a really one of these really weird, rare things, but it happens, and when it happens, it can get really ugly. I've had one practitioner where in the course of 5 years, they prosecuted hundreds and hundreds of applications, and all without their license, with their license having been administratively suspended without their knowledge. And one of those, of course, one of those patents, of course, matures into one of the applications matures into a patent, gets into a litigation, and the other side in the litigation figures out, hey, wait a minute, this guy wasn't registered when he did all of this work, and therefore, you know, this patent, it's meaningless, it's nugatory, it was illegally filed. It's unenforceable. It's like a new theory of inequitable conduct. Now that's just an allegation, and I don't think it's going to gain any real traction for a variety of reasons, because it doesn't really fit within the mold of our inequitable conduct jurisprudence, if there's no knowledge and intent, certainly. But there are cases that are out there where the wrongs of the agent, attorney, fall upon the client, principal agency doctrine, you know, and if your screw-ups are, as a matter of law, imputed to your client, and there are cases where courts have found actions that attorneys took while they were suspended, knowingly or not knowingly, but in the case where it's not knowingly, clients have lost cases based on limitations lapsing because the court says, well, this was an invalid filing. We're going to treat it as if it was a nullity. And it's got to be refiled. And then limitations is run. And then we'll talk about in our second hour about the malpractice elements of that. But it's just a little tidbit for from the front line, so to speak. So a little bit about OED, what they do. I noticed when I came in today that it looks like the Iowa State Bar Association has been around for a long, long time. I think the wall downstairs says since 1874. That's pretty impressive. The OED, not so much. A very recent creature came into existence in 1985. Now the Patent Office has been around for quite a bit longer than that, but it was only until the mid-1980s when people started thinking, gee, maybe we should have some sort of an organized bar and application and formal registration requirements and ethics rules governing people who are engaged in patent and trademark practice, especially because we're one of the few areas of law, really the only main area of law. There have been some narrow exceptions carved out, but for the most part, patent agents hold kind of a unique role in the delivery of legal services because they are not attorneys by definition, they're not admitted to any bar, and yet they are fully authorized to practice law as not being an attorney. Now, the scope of what they're allowed to do is limited, but for most patent agents, that's limited to the extent of that's all they really care about. It doesn't matter. The other the things they can't do, they would care less about anyway. But for preparation, prosecution, advising clients about patentability, all of those things related to the patent application and acquisition process, an agent can get those. And agents don't have to go to law school. Usually they don't get any formal training in ethics. And so they thought, well, you know, we need to have something that captures the agents also, that has them held to some sort of level of accountability. And right now there's about 40,000 active registered practitioners in the United States. When you take out the older numbers and the people who have been deceased, they can just keep a running number. So I don't know what number they're actually up to in terms of registrations. I think they're like in the 80,000s by now. But of that body, there's like about roughly 40,000 active registered patent practitioners. Of those 40,000, 25% are patent agents. So that's a pretty significant number, 10,000 or so who are agents. 1/4 of the patent practitioner workforce in the United States doesn't have a legal background, other than the fact that they passed the patent bar exam and that they passed the character review portion. So what is the The D side of the OED does is they investigate. They've got this body of rules that they created in 1985 to regulate attorneys' conduct, regulate what they call practitioners' conduct, and their job is not just to promulgate the rules, but to enforce the rules. And so if the rules may have been violated, the D side of the OED, the part that you don't want to deal with ever, the ones that send the certified mail letter, the D side, that's their role, is investigating whether or not the ethics rules governing the PTO have been violated by practitioners, a practitioner. And practitioner is a term of art. It's defined in the CFR. Generally speaking, it includes anyone who's registered, patent attorney, patent agent, anyone who does trademark work before the PTO is considered a practitioner. And then there's a couple of little quirky areas where you can get, for example, limited recognition. If you have a visa, if you're in on a visa and you've got some work support that supports you via visa, there's something called a limited recognition. Very, very few people have those. And there's also a reciprocal arrangement that we have that's effectively only as between the US and Canada, where Canadian licensed patent attorneys, what they call patent attorneys, what we would call patent agents, they can represent Canadians in matters before the USPTO, and reciprocally, because we allow Canadians to do this, they allow us to do that there. So we have this reciprocal arrangement. Again, it's limited in scope. Not so many people are in those different pockets. And then you have other one-offs, like if you're involved in a inter-parties review and you can get admitted into the matter pro hoc vice. If you pro hoc vice in, just like you would in a court proceeding, you're then agreeing to be held by the PTO's ethics rules. One area that I've seen where the PTO says there are 20,000 trademark practitioners, or at least the OED says that. And I'm not exactly sure what that means. What they think it means is that 20,000 people who are substantively engaging in trademark practice, who are signing off as the responsible attorney, the attorney of record, I think is the term in the trademark world, right? But I have been involved in cases where I have had clients who they were not registered practitioners, they weren't registered patent attorneys, they weren't registered patent agents, they were attorneys. They didn't do any trademark work. None, zero, zip, nada. Not a single trademark case. However, their firm on the power of attorney form, I don't remember the name of the form, but it has a section for other authorized people, right? So if the trademark examining attorney can't get in touch with the designated spokesperson, they list a bunch of other names of people from the firm as contacts who are also authorized to speak with the office on behalf with regard to the matter. And sometimes practitioners will get those phone calls randomly. It doesn't happen all that often, but just because your name is on that list. And this individual, his name was on that list along with like 50 other people from the law firm, because they just put everybody in there in that other context. And he had to go through like a 1.5 year investigation, and the only thing holding him into the whole proceeding was this argument that he was a practitioner and therefore under their jurisdiction, and the predicate for that was because of this form in which his name had been listed on, scores, if not hundreds of times, without his knowledge, without his authorization. But it just was a matter of firm practice. And I know in my former firm at Oblon, we did that all the time. I didn't do any prosecutional work at Oblon, but my name was listed as a person authorized representative, even though I have a reg number, so it really didn't matter. But Still, my name was listed along with 50 other people, and every once in a while I get a phone call from an examiner about a particular case. I'm like, okay, I don't know what you're talking about, but we'll get back to you. So they take a very broad view. They can take a very broad view of what it means to be a practitioner. Now that case ultimately went away on the merits, but it would have been a battle of as to whether or not that person was really within their jurisdiction. What is this organization? And just to give you a sense of its own self-purpose, it's a law firm, basically. It's a law firm at the USPTO. Have you all ever been to the USPTO, gone there for interviews? So they're in the Madison building, the big glass, showcase building at the end of Delaney Street, and it's a law firm up there. They've got half the floor are for solicitors, the attorneys who represent the USPTO director and other aspects of the agency and litigation, and on the other side of the hall is OED. And they've got a very substantial staff. They've got a managing partner, I call him managing partner, he's called the director. And he's got a second in command, he's got a third in command, and he's got a bunch of minions, which I'll call associates or of counsel because they're more senior, but they're all investigators. All of they do 24, well, not 24/7 so much because they do work for the federal government. So 9 to 5 minus the 8 weeks of paid vacation and all of the federal holidays, they're out there actively engaging in investigations. And occasionally they'll deal with one of these enrollment issues, but enrollment portions are a pretty small piece of what they do. Enrollment is really, they'll get involved in an enrollment matter if it's a character issue that arises, and the character issues almost inevitably arise because of some criminal conviction that somebody has disclosed on their application. So it's really focused on the discipline side, and what they do is investigate. They have a very robust staff. Now, I'm not suggesting that just because they have a big staff of people that they need to keep all of these people busy, because, if you're a law firm and you've got 15 associates and those people aren't pulling their weight, what do you do with those people? Like in a law firm environment, I know what you do with those people. Those people are, let go. But when you're a federal government employee, it's a little bit harder. You have a lot more job security. So I'm not saying they're trying to find work, but they're trying to find work. They do things that other bars just would never do, okay? And what I mean by this is, for example, in many bars, they will not consider the term of art is called a grievance, okay? In many bars, the process for initiating a grievance against another attorney or an attorney, whether it's by a client or from someone else, is you prepare a written document. It's got some, templated form, and you sign it, and you maybe even swear to it, and you submit it, and that's the grievance, right? And that makes sense. It's like a complaint. The PTO, though, has a much broader definition of what constitutes a grievance. And so a grievance is any information that the OED receives that suggests that a practitioner, remember that term practitioner, may have violated one of the PTO's ethics rules. And the source of the grievance is not defined. It's not limited in any sense. It could be in writing. It has to be in writing to constitute an official grievance. So a phone call won't do it. But a newspaper article will do it. That's in writing, I think, right? Electronic, anything on, I don't know if you all subscribe to some things like Law 360, IP 360. They do. They subscribe to IP 360 and Illegal Ethics 360. And there's a bunch of stuff that goes on in there that every week there will be information that comes out of those articles because bad news leads, right? And so they'll get into these articles and they'll find out about some judge who, chastised some patent litigator for, violating Rule 37 because they, withheld material information and they get discovery sanctions. The OED will read it, they'll pick it up, they'll say, look at all, find the practitioner, they'll find the attorney's name, they'll run it against their database, boom, 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 oh, he's one of ours. And off they go and process. And just many bars, you know, they're not that proactive. They're not out there on the street corner actually, you know, looking for things, but OED does. And I think one of the reasons why they have to do it is a little piece of an amendment to the AIA. The AIA was enacted in 2013. There was a modification to 35 USC 32, which dealt with, it includes, it's a big long section, but it includes, it's general authority of the office to regulate the conduct of practitioners. And it's the enabling legislation. Before the amendment in the AIA, the statute of limitations was 5 years for the USPTO to file a disciplinary complaint against a practitioner for violating the ethics rules. 5 years from the date of occurrence. And they didn't have an official statute of limitations that was incorporated from another federal statute, and that's what they used. So in the AIA, they said, you know, we really 5 years isn't enough time for, you know, there's a lot of times we just don't learn about things until, you know, it could be 6 years, 7 years, 8 years. And by the way, many bars don't even have a statute of limitations for filing a disciplinary complaint at all. It's they may have a practical one, but most bars it's very long term if they have one at all. And so in the negotiation of this particular provision of the AIA, they said, fine, we'll give you 10 years. We'll make the term of 5 years to 10 years as an absolute bar. If the conduct occurred within 10 years, longer than 10 years ago, then there's an absolute time bar, okay? But, and this is the kicker, it's the lesser of the 10 years from when the events occurred, or 1 year from the date when the OED learns about it through a grievance, okay? And it's the 1 year piece that really is the engine driving the train. That 1 year piece is huge. That is not a lot of time. When you couple 1 year of when the OED director receives a grievance and tie that together with a grievance being something I might write on my blog or that they read about on Pat and Leo or on Gene Quinn's IP Watchdog or in any way, shape, or form. And when you tie those two principles together, you should have a very short limitations period as a practical matter for most cases. Most cases that I've dealt with, the 10-year bar is an opposite. It doesn't come up, ever. I haven't had a single case where the 10-year bar has been an issue. If it has, it's only been only to the extent it limits the conduct that occurred 10 years or more prior, but for anything that occurred sooner than that, it wasn't a limitation. But that 1 year from the notice is huge, and that's why they had to ramp up their staff. 6 years, 7 years ago, OED was a really sleepy little organization. There was a guy named Harry Motes who ran it, and you know, they had a very laissez-faire attitude about ethics and discipline, which is all fine, I guess. And, that was just his style. They didn't have a lot of cases. They didn't really were very particularly aggressive. When they had them, they went after them, but they didn't have so many. But in the last 7 or 8 years, and particularly in the last 5, and since the, especially since the change of the law, their number of investigations have gone up dramatically, and their number of cases of published discipline have gone up dramatically from before, where it might have been, you know, 1 or 2, maybe 3 in a year, and sometimes they go several years without anything. And now I see 25 or so to 30 cases per year published. Those are the published disciplinary decisions. So that's a huge sea change. So to get all that work kicked out, they have to have a real process set up. And the office itself is actually run by a colonel in the U.S. Army. And he runs the office with a particular sense of military-like discipline that brings matters in control. I like the guy very much, except when I don't. And but he has a certain sense of order and a certain sense of again, like military organization, and so dates are not missed, and people are double, triple, quadruple docketed, and they've got their act together. And also that office, though, takes kind of the lead of its leadership, and the OED director has a particular view on certain things, and he views things certainly harshly, sometimes more harshly than others would. And I've seen in other situations where he's viewed things more compassionately, surprisingly, to my own view, like, wow, you're really being nice here. That's good for you. You've got a soul. It's not just all about, you know, knocking people out, but they're geared up. One other sort of final point before we get into the sort of more substantive stuff. What are some common misperceptions that clients and maybe members of the bar in general have about their exposure? The number one is that it doesn't make a whit of difference whether your conduct arose in the context of your delivery of patent or trademark services. It doesn't make one whit of difference whether it even dealt with the practice of law in general. Just like the state bar, they regulate your conduct, and your conduct includes your personal conduct and your professional conduct. It's not limited to just what you do in the office. Another misconception is that the investigations they do, that people can find out about them. That's untrue. Everything that goes on in the Office of Enrollment and Discipline is governed by something called the Privacy Act, 5 U.S.C. Section 552. It's a general federal statute that encompasses a lot of different agencies. It is kind of a blessing and the curse, this Privacy Act, because the blessing is if you're the target, your name's not going to be published anywhere. No one's going to know that you're being investigated unless you go ahead and tell them. It's not going to be out there in the social media world and for people to bash you. Oh, he's under investigation, she's under investigation. So all of that stuff is under wraps. The flip side of it is, though, if you are trying to understand how the OED operates and how they process cases and what they're thinking is based upon precedent, which is how we normally have learned to do things, I think, as lawyers, is you do things you learn from others' mistakes, and there's a lot that's left hidden that you all won't, and I also won't ever even know about. Things that have occurred that or are occurring that I know about things, the things that I handle, so I get a pretty good taste of it. But I don't pretend to have all of the cases. My wife wished I did, but I don't, and it's there's a lot of stuff that goes on so that we can't look at it and say, oh, I didn't realize that was a problem. And you know, so people can sort of not be aware of things that are actually of concern to the OED until they get that certified letter return receipt requested, or in one of those circumstances where the OED actually publishes a disciplinary decision. A couple of other things, more minor. If you settle your case, let's say you have a client that's the grieving party, you missed the filing date, they're ticked, they file a complaint with the OED, you settle with them, you make them whole, pay them, you know, you do what you can do to make the case, you make them happy. That won't make the OED investigation go away. It's separate. They can continue their investigation. They're not limited in any way by settlement. Resigning from the PTO bar, or resigning your ability to practice and trademark matters before the office, will be treated as if you were disbarred. So I've had clients who have been in a ticklish situation where they're facing real-time discipline, and they don't really do a lot of patent or trademark work, or maybe they don't do any, but they're being investigated because of fraud that occurred in their real estate practice, right? And somehow it gets known to the OED, and the OED picks it up and they start running with it. And people will say, well, I'll just quit. I'll just resign from the OED. I don't care. I don't do any business with them anyway. But I do need my law license in my state to continue doing what I'm doing. So if you resign, though, you are considered by everybody else to have been disbarred. And that disbarment then will get reported to all of your other bars that you're a member of. So you can't resign your way out of it, unfortunately. It'll follow you around, unless that's your only bar, which means that you're a patent agent. If you're a patent agent and you resign, then that's sort of the extent of it. But for anyone else, including attorneys who, many attorneys could don't really care much about whether they don't do any business before the office. Like my one client I mentioned about the jurisdictional issue. Care less about, doesn't do trademark work. It's not registered. I don't care. I don't want it. If I could just resign from it, I would. But if you resign while you are under investigation, that's the key. You can resign at any time if you want, voluntarily. But if you resign while under investigation, it's treated as a disbarment. Then it gets reported to your states, and most states will reciprocally disbar you as well. And which goes to my last point, USPTO discipline won't affect your state or federal law licenses. That's absolutely false. The states recognize it's a full faith and credit clause. They've learned from constitutional law. So a decision from the states, the PTO accepts it as is. You've got a little bit of due process in the PTO, but essentially if you get disciplined by a state and you're under their thumb, they'll impose the same discipline, and it works the other way as well. If the PTO disciplines first, and then it gets reported to the state, then there will be a reciprocity rule will kick in, where the state will look at whether or not they should impose the same discipline. So it can very well affect how you work. So, okay, that's the office. Let's go to some of the big issues that I see that ultimately are bothersome, and they come up again and again and again. It's just the nature of how we do things. And that is the very simple concept of who the client is, knowing who the IP client is, and knowing who the client is in a real legal sense. And why does it matter? Well, among other things, nearly all of the rules of professional responsibility are predicated on a client relationship. A lot of the big ones anyway. Now, if you're doing bad acts, there's plenty of rules that govern things that don't necessarily require a client relationship. But some of the big ethics rules do require, and when I say big, the ones that come up in the beginning, like the first rule, the duty of competence. That's a duty that you owe to your client. You don't, so by definition, you don't owe that duty to a non-client. So whether that person is a client or not a client really matters. Same with the duty of confidentiality. Same with the duty of communications. Same with the conflicts of interest rules. The rules regarding fees, diligent representation. There's a whole section of rules that are just for the benefit of the client. So it does suggest that knowing who the person or entity is that is the client to whom these ethical duties are known is important. And I have found in our space that a lot of times there's either confusion or lack of understanding or not a real a disciplinary approach to defining who the client is. And so we'll get back into that in 1 second. So there is no, ironically, even though all of these ethics rules, or a bunch of them, are predicated on there being a client relationship, the ethics rules don't define who a client is. They defer to the common law. The common law generally defers to the restatement of the law governing lawyers as to when there exists an attorney-client relationship. And it's this test that is on slide 11. It's a person manifests to a lawyer that the person's intent that the lawyer provide legal services for the person, and either the lawyer manifests to the person consent to do so, or, and this is the one that gets people a lot of times too, the lawyer doesn't manifest a lack of consent. You get double negative. Lawyer fails to manifest a lack of consent to do so, and the lawyer knew or should know that the putative client person reasonably relies on the lawyer in believing that they're their lawyer. So the whole question is, hey, I didn't know I was your lawyer. I wasn't undertaking representation of you. When we sat here at this cocktail party and you were telling me about your legal problem and, I gave you some advice about it, I wasn't intending to enter into some sort of a attorney-client relationship. We didn't have a fee agreement. Well, the bar doesn't, a fee agreement isn't necessary. And the rule is designed for the benefit of the client. If the client reasonably believes and you don't do anything to dissuade them, then there have been there's a lot of cases that are out there where lawyers have inadvertently picked up a client relationship, whether they knew it or not. And then that sort of has a lot of other implications. If you think about it, once somebody is tagged as being a client, how long are they a client? When are they a current client? When do they become a former client? That ambiguity in that as well will then permeate over to conflicts of interest. All of a sudden now you're going to take a position adverse to that person that you didn't even know was a client, but they're saying that they were a client. Well, how do we deal with that? That becomes very hairy, and it's not in a good way. It's a bad way, and the lawyers are having to defend themselves to say, well, I never intended blah, 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 blah. But you see, the regulators, the bar, and the courts are very, the rules are very much in favor of the consumer, right? Very much in favor of the consumer. Especially, God forbid, if it's an unsophisticated consumer, whatever that should mean, whatever that definition of unsophisticated is, but if they are found to be an unsophisticated consumer, as my uncles in New York would say, forget about it. You are toast. You will have this client relationship whether you wanted it or not. And so I dealt with this as the risk management person in my old law firm. It came up almost on a daily, but certainly on a weekly basis as to who was the client in a particular matter. Because we would enter into our docketing system. So we had a very I thought we had a very sophisticated, we had a machine. We handled thousands and thousands of patent applications, and the only way you can handle thousands and thousands of patent applications is to have a real good assembly line process. A lot of people tasked with a lot of different things along the line, the assembly line operation. And I don't mean to denigrate it in it, it's just the nature of the business. You've got to have a lot of different things covered. And a lot of those rely upon non-attorneys to fulfill their tasks and in supporting the attorneys and the patent agents within the firm. And so when we would enter these relationships into our master database of people, we would always refer to them as a client, but we would refer to them as a something client. So one would be a maintenance fee client. I love that one. Maintenance fee client, foreign associate client, secondary assignee client. That's a good one. There was no something that just said client, like this is the client. And so people would hand me the files and say, and I would have to resolve the conflict issue. And I'd have to deal through all of this. What does that mean? They're a maintenance fee client. Well, we just pay maintenance fees for them, so they're not really a client. They're just a maintenance fee client. Okay. Well, what do they think? We go back to that reasonable belief piece in the, are you sending letters to this client or non-client, this so-called maintenance fee client, saying our relationship has ended? However, I will, send you reminders periodically to let you know the things you need to do to keep your IP rights enforced for as long as you can enforce them. And I will be happy to service you and do all of the things necessary to keep your patent or your trademark alive for as long as we can. you know, those types of correspondence come back in litigations as Exhibit 1, 2, 3, and 4 as the proof of the client relationship and whether they reasonably believe that you were their client. So the patent prosecution is a real, and trademark prosecution, sort of same sort of thing comes in. I don't know if you all do business with foreign law firms or so-called the foreign associates. Any of you in here that just raise your hand if you do, your firms do any work through with foreign associates and foreign law firms. It's a significant body of U.S. patent work that originates from overseas. And whether their cases are filed first in the United States or filed first in their country of origin, it's really neither here nor there. Case comes to the law firm from the foreign associate, the client, because they're the ones that we're talking to. They're the ones that are referring to us all of these different cases. And by the way, these foreign associates, for the most part, they expect some quid pro quo back, right? They aren't just doing this out of the goodness of their heart. They're picking law firms that they want to establish relationships with. And in return, they kind of expect that if you're giving us, we're giving you cases for your country, then when your client in your country wants to file in our country, you're going to refer that matter to him, right? Sure, this makes sense. It's a normal business relationship. Foreign associate contacts you, says, okay, here's an application needs to be filed. It's got several inventors on it. You've got 3 inventors in this hypo, and 2 of them have assigned, there's an assignment recorded with, or a paper assigning the rights to company A. All subsequent communications, the firm gets it, they docket it, everything goes back and forth between the foreign associates. Whatever needs to be signed, whatever needs to be reviewed, it goes to the foreign associate, and then at some point it comes back, and invoices are submitted to the foreign associate, invoices are paid by the foreign associate, in my hypothetical. And the question is, in this context, who is the client? And so who are the people that are involved? We've got the foreign associate, we've got 3 inventors, 1, 2, and 3. We've got at least 1 assignee that we know about, company A. Is it all of them? Is it some of them? First of all, anyone in here think that the foreign associate is the client? Raise your hand. You think the foreign associate is the client? There's no shame in believing that, because most of the people in my old law firm believed that the foreign associate was the client. Because of course they're the client, because they're the ones who we're communicating with. They seem like the client because they've got that, it's like they're almost like in-house counsel. It's that close of a relationship. And they're paying the bills, which is almost for everyone's definition as to who's the client. It's like, where's the money coming from? And I'm going to tell them they're definitely going to be my client. But in the law, foreign associates, as a matter of law, are not the client in our context. Okay, you might want to refer to them as clients, but as a legal matter, they're not clients. They would be, if anything, agents of the clients. So what about the inventors? Okay, well, what does the law say on patents? That the inventors are the owners of the patent rights, right? Unless they assign it or they have an obligation to assign it. So we have inventors here. We've got 3 inventors. Who here thinks that the inventors or any of the inventors are the clients? Anyone think that any of the inventors, we have 3 inventors, inventor 1, inventor 2, who have assigned. Does anyone here think that inventors 1 or 2 are the client? No? Okay. Does anyone here think that company A is the client, assignee for the inventors 1 and 2? Good. I think that's right. But now we have inventor 3. Okay. Who thinks that inventor 3 is the client? Well, maybe yes, maybe no. Is there a circumstance where you can think that inventor 3 is not a client? What would be a situation where inventor 3 is not a client? Just shout it out if you know the answer. It's okay. What if they don't, they just, I don't know, so they don't have a duty to assign to anybody. They're just out there. So they're just out there. We don't know. The issue is we don't know who they are. We, the law firm, don't know. And that is really important because number one, they might very well have a duty to assign to somebody, right? And we need to know that. If they have a duty to assign, we need to know who their assignee is, because that could pose a conflict of interest for us. Because once we've got to figure out who these people belong to, and whether they're going to establish this matrimonial-like relationship of attorney and client, we need to know, or are they married to somebody else, or are these free agents, or what? Are we going to take these on as clients, or we really want to take this individual, inventor number 3, on as a client jointly with company A? Do we want to do that? I mean, you can. There's nothing, you can represent joint clients, but that raises other issues. So the duty is to figure out who these people belong to, and at least with respect to inventor 3, at the very least, we need to know more facts. We need to know who they are, do they have a duty to assign, was it just left out inadvertently, are they really part of company A and it was just left out? We need to know. A lot of times these foreign companies deal with, they get involved in joint ventures, and their invention ends up being the result of a joint venture. And they might have multiple named inventors, and got several people from one piece of the joint venture and several people from the other piece of the joint venture. And the question can become, do you represent the joint venture, or do you represent one part of the joint venture or the other part of the joint venture? Raises some ticklish situations, and this gets into the joint client role, because of course it is ethically permissible to represent joint parties, but you've got more due diligence to do, and you've got more communication you need to do. Because if you're representing 2 different parties, whether they're individuals, or if it's an individual and an entity, whether they're 2 entities, whether they're 10 entities, they each have client status, and they get to be the ones that they are protected by all of these ethics rules that protect clients. Now, if we start putting one in front of the other in line, clients 2, 3, 4, and 5 might not like that. If we're saying that, well, client 1 is our only client, we're really just going to respect client 1. And you're incidental clients, you're tangential clients. Another term that I've seen used in our business. Well, what does that mean? You're a tangential client. That means you're still a client. You just can't say you either are or you're not. It's like you can't be a little bit pregnant. You are or you're not, and there's no sort of middle ground. But what you can do, and this happens with the joint venture. Joint venture comes up a lot, where you've got company A that is your long-term firm client. You've been doing work for them for 20 years. And they come to you and they bring to you a matter in which they created a JV, and the JV is a separate entity, organized entity. Maybe it's an affiliate, or a lot of times it's commonly owned by company A and company B. And this is a very common thing. Happens in the States, happens overseas. You've got universities doing things with people and companies. There's a lot of places where there are joint relationships involved. And you've got to sort that out at the beginning to figure out who is your client. And if you're going to be taking on these multiple clients, that's okay, but who are you taking instructions from? Who are you going to communicate with? Especially when you get in a situation where you don't want to get in a situation where you're being viewed as taking sides for one client over the other client. And anything that happens that is in hindsight viewed to be adverse to one of the clients, they're going to say, you were protecting the other person. You weren't giving us the loyalty that you owed to us. And so the way you need to deal with that is up front, at the beginning, the start of the representation, which is something into the effect that, look, you guys can do whatever it is that you want, but we cannot take instructions from everybody. Right? That just doesn't work as a process matter. We need a conduit. And if you all say that this person here, or this entity, is your spokesperson, and he or she or it speaks on behalf of you all, then that's fine. We all agree to that. That's the structure. All of the instructions or questions or advice, it all flows through this person. And that is the person who speaks on behalf of both of you. If you all have a difference of opinion between the two of you, that's between the two of you. And maybe something you all work out, or if you can't, maybe that will raise an issue. But for us, we can't have to go to you and say, okay, here's how we want to amend the claims. And then I have to go to you and say, what do you think? Is this okay? And then, we start spending hours and hours and days rewriting, and, it just doesn't work as a process matter. So we need to have something set up that allows us to do it. It's definitely doable, but you just have to be mindful of what some practitioners get so comfortable with what they'll call the lead client, the primary client, the one that they've gotten all the work from, where they get this tag along, that they just sort of give them secondary status, secondary citizen status. And that was actually a term that we used at my old firm, secondary assignee, which is a real fancy way of saying another client. But what secondary assignee is, it's like, well, we have our client and they're an assignee and they have a co-assignee who would also be our client. And so we need to deal with that. And then the only way you can really ethically deal with that without getting yourself in a lot of downstream trouble is to have an agreement. You've got to be proactive in communicating with the assignees and joint assignees or co-assignees and saying, look, this is fine. Who's paying the bills? Who are we communicating with? And you all agree by doing this that we can do it this way. And if there's a difference of opinion that results between the two of you, we may have to back out of the representation altogether because we might not be able to do it. So there's an inherent conflict coming in. You understand that there is a potential for a conflict of interest when you represent more than one person. It's waivable, but you at least have a duty to inform these people that they have, you have the right to get independent counsel. It might be in your interest to do so. There's some benefit to being represented by a common counsel as well. There's upsides and downsides. It's ultimately your choice on how you want to do it. But we need to work out how it is that we're going to be, working this from a process flow standpoint. Because if that doesn't happen, you're going to end up like these guys in Newman. And I say guys because it just happened to be two men. And so there's a lot of different clients involved in this, but you've got two young women who are forming a joint venture to market a product that they've got a trademark for. And this is a real fact pattern. They are client 4 and 5 in this fact pattern. And one of the clients is the daughter of another client, and there's an entity that's formed on behalf of these people, and you've got a whole bunch of different entities involved. And the service partner, the partner that's in charge of this, they basically view the father of one of the daughters. So the two joint ventures, and the father is really, he views the father as the client. Because the father owns this company, they do a lot of work for the company, and the father basically says, hey, look, my daughter and her business partner, they want some help with a trademark, can you help them out? And the attorney says, sure, of course, we'll help them out. But the father gets his nose in all of the business, and it's the daughter and the daughter's business partner who are the true actual clients. Father says, oh, I'll pay the bills too. Don't worry about it, I've got this covered. And so the father gets involved, and the father has a company, and the company is involved. Long and short, the daughter's partner, at the end of the day, the father and the daughter decide that we're going to go in a different path, and we're going to have you all, law firm, cancel that trademark, and we're going to go with a different trademark. And they do that, and they don't tell the joint venture or the other client. They just go ahead and do it. they just were very lax about their sort of, okay, the communications were coming from dad, and they were having phone conferences with dad involved. It was not the client, so there was no confidentiality, no attorney-client privilege, because dad was a third person, but it was all treated very informally. And at the end of the day, the co-owner of the company with the trademark that was canceled without her consent was like, you know, what about me? What about me? So those are two very fine attorneys from a very fine law firm, and they got suspended from the PTO. They had no history of discipline. One of them had been practicing law for 30 years, didn't have a inkling of disciplinary history, but it was a tough situation for them both. And even a 30-day suspension is not, it's there. It's on your permanent record, as you like to say in school. It's not something that you're going to be bragging about to your clients. So clients, who the client is. And this gets into the transition to intermediaries.